Well, hello everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, and we are here today with some news concerning Tiger Woods, whose ex-girlfriend, Erica Herman, has sued him in state court, arguing that a non-disclosure agreement that exists should not exist with respect to her. She'd like the non-disclosure agreement to go away. So, what we can infer from this is that probably very early in their relationship, Tiger Woods had her sign a non disclosure agreement, which makes a lot of sense as a practical matter because he's a very famous person and she would have an ability to see a lot of aspects of his private life that he'd like to keep private. And he'd like to have an aspect of his life that's private, which makes logical sense. So you could, of course, infer that this is more nefarious, or you could just infer that this is just a guy who has been in the public light forever and would like to have aspects of his life, including his dating life, be a little bit more private. He'd like to choose to keep certain things private. And so a non disclosure agreement makes a lot of sense. He probably has non disclosure agreements with everybody that's sort of in any sort of position to be within his inner circle so that he can live some sort of semblance of some sort of private life, or at least have aspects of his life that are outside the public eye. Well, whatever the motivations for this non-disclosure agreement might be, it exists and she is suing to have it not exist. So we will read an article about the thing and then we will read the lawsuit about the thing. And so let's go ahead and do that. So this is an article that describes the thing from the New York Post. Tiger Woods' ex, Erica Herman, wants the non-disclosure nullified, apparently over sexual harassment. So there's a federal law that applies on this issue, relatively recent federal law that applies on this issue, that says non-disclosure agreements are invalid with respect to certain claims, sexual assault and harassment. And so this is one of her legal hooks to try to get this thing at least partially nullified. So we'll see about that. Tiger Woods' ex-girlfriend, Erica Herman, has filed a lawsuit against the golf legend asking her to be removed from the non-disclosure agreement, citing a law that allows them to be voided if there's proof of sexual assault or harassment. This doesn't necessarily, of course, require that Tiger Woods himself is the one who did the harassment, because the non-disclosure agreement probably concerns everyone within his inner circle. And so it might be an employee, it might be a contractor, it might be a friend, it might be a whole bunch of situations. But she thinks, or she's at least claiming, that there is some sort of sexual harassment or assault. And I am somewhat cautious on this because the thing that is interesting, of course, is that non-disclosure agreements are typically valid. They are a matter of contract. But federal law recently came in and said, okay, in this small domain, we're going to nullify them as a matter of interstate commerce, right? These are restricting trade, these are restricting commerce, and we're going to nullify them in these small respects. So you have to at least wonder about the possibility that you're using it as a wedge to nullify the entire agreement rather than on the merits of the thing. So it may be that there are merits of this thing. I have no idea. But you should at least contemplate the possibility that we're using this little wedge that exists to try to either force ourselves into a category we don't really belong into to get the legal protection, or potentially make something more salacious so that they'll agree to waive the non-disclosure with respect to whatever it is we really want to talk about so that we can get past it. So there's a lot of potential motivations here that are potentially in play. Herman, who is 38, is seeking to legally nullify the NDA she was made to sign in August 2017 when she first started dating the 47-year-old golf star. She claims the NDA shouldn't be enforced because of the Speak Out Act, this federal law, which was put in place to protect sexual assault and harassment victims. There are, of course, no specific allegations of assault or harassment referenced in the court document, because that would be a little bit problematic. But that's the legal hook she wants to use. Okay. And here's a picture of her for whatever value that has, just to show you what she looks like. Herman, who's a former restaurant manager, claims Wood is trying to enforce the NDA via his trust and so called litigation. So the NDA that he has is concerns him, but is not necessarily held by him proper. It might be held by a different legal entity. So he has a non-revocable trust, which also makes sense for a lot of legal reasons. And perhaps the non-revocable trust is the one that has the NDA, strictly speaking. He controls it. So there's separation between him and the corporation form is perhaps a little bit more tenuous, but still it's a separate legal entity. According to the complaint, Herman is also seeking clarification from the court on what she's legally allowed to disclose about her 6-year relationship. Okay. The uncertainty is acute and important, her attorney wrote in a 5-page filing. We will review the 5-page filing for what it's worth. Because the aggressive use of Wood's NDA against her by defendant and trust under his control, they're unsure about what they may disclose, among other things. Gaming facts rise to various legal claims. Well, again, I would imagine the NDA is fairly expansive, and there's nothing necessarily nefarious about that. You could view it nefariously, but you don't have to. NDAs are fairly common in business. They're not common with between lawyers and clients, incidentally, for what it's worth. And there's actually an interesting ethics issue about whether a lawyer can actually sign an NDA with respect to their own client. And I'm of the opinion the answer is no. But that's another discussion for another time. The reason being, by the way, because lawyers don't need NDAs, because we're bound by other rules. And the reason that reason a lawyer might not be able to sign an NDA with respect to their own client is because you're potentially stepping on top of those rules, and some of those rules are ethics that are imposed by law. So it might try to circumvent the protections that exist at law because it's a trusted relationship that has legal protection. So NDAs create problems actually for lawyers with respect to their own client, in case you care about such things. But I digress. In any event, with respect to other businesses, it is not uncommon for there to be NDAs because, unlike lawyer client, which has a relationship that's been defined through antiquity, and the nature of the confidentiality has been defined through antiquity, most business relationships don't have that. So they need to impose it themselves as a matter of contract if they want it. And it's not uncommon for them to have NDAs with respect to things that you wouldn't otherwise see. It's like if you want to come inside the envelope that is the private affair, whether it is the business or the personal relationship or whatever, you want to come on the inside, then you can't expose things you learn from the inside to the outside because that's not fair. Right? Whatever's in the public space is in the public space, but you're coming inside. And you shouldn't be allowed to expose things that you only learn from the inside. So, fairly common, totally understandable. And for a person like Tiger Woods, who I imagine has quite a few employees and contractors and things like that, makes a lot of sense. It's like, yeah, I don't want you basically to discuss things you learned about from the time that you were inside the envelope, because the only reason I let you inside the envelope was because of the protection that we have. And I don't want you to expose that because that's why it's inside the envelope as opposed to outside in the first place. So there's that. On civil law, have you heard of an NDA for a personal relationship? Uh, no, not really strictly speaking, no. But then again, this is a fairly famous person. And if I were in Tiger Woods' position, I think I'd do this too. Because if I had a life that was constantly in the public eye and people are always looking for the next, the next insight and the next juicy bit and the next bit of intrigue and the next bit of gossip. If I was this kind of person and I wanted some semblance of a private life, I think I'd have an NDA in a private relationship too. So have I ever heard of an NDA in a private relationship? No. But then again, most people don't have these levels of concerns. So it seems quite proper in this And maybe we should have NDAs in private relationships. I don't know. Maybe there'll be a new part of dating. Maybe there's a business to be had there. But it makes logical sense for him, at least. She is also unsure about whether information about her life she may discuss or with whom. There's therefore an active dispute with plaintiff and defendant, which the plaintiff needs clarifying declaration. So she's suing for declarative relief, and she'd like the court to declare what is true. Okay. In the instance, a judge rules the NDA is valid. They want guidance on whether she can publicly share photos and recordings of herself and her family, as well as information from sources who are not bound by disclosures. Here they are together in happier times, I guess. While the complaint doesn't spell out if the couple's officially split, it does note that Woods and Herman have a long relationship that is both professional and personal. Herman is said to have met Woods when she's working at a bar while studying at the University of Central Florida in Orlando. I toured the University of Central Florida as part of my schools to potentially apply to. I think I did apply to UCF, as a matter of fact. I believe I got in. That was a long time ago, but okay. She then tapped by Woods to run his Jupiter, Florida restaurant, The Woods, which opened in 2015. After the golfer split from Kristen Smith in 2017, Woods and Herman went public with her relationship in September at the President's Club at Liberty Golf Club. At the time, Herman was spotted wearing a player's spouse credential as she mingled with the now wife golfer of Jordan Spieth. In 2018, TMZ reported that Woods and Smith were in arbitration over a non-disclosure agreement. Smith is said to have ended her relationship with Woods, who had previously sought treatment for sex addiction after suspecting he was unfaithful. Tiger Woods may potentially have issues with faithfulness, which, I go back to, what was it? Bill Burr's joke on this issue. I don't have a whole bus of Scandinavian ladies just demanding me be with them and just be like, sorry, ladies, gotta go home. So yeah. The last time they were spotted together was during the US Open tennis tournament in New York in August of last year. Herman was noticeably absent from the PGA Tour's Genesis Invitational Tournament in February, the first time competing on tour since last year's Open Championship. Okay, so that is the article concerning the thing. Let us read the lawsuit concerning the thing, which doesn't provide much more information than the article, but still, it's always nice to go back to the original material. So the plaintiff, Eric Herman, files a lawsuit against Eldrick Woods and states the following. This court has jurisdiction because it's an action for declaratory judgment pursuant to law. This is a matter of contract. NDAs are contract. The contract exists as a function of state law, presumably Florida state law. We'll assume for the moment, which makes sense. And so we want to get declaratory relief to help define our contractual rights. Okay. Plaintiff is an individual with this residence. Apparently, they live together at the moment. That must make service awkward. Venue is proper in Martin County because the defendant resides there. Fine. This case involves a purported non-disclosure and acknowledgement agreement dated August the 9th of 2017. The plaintiff has had a long relationship with defendant, both professionally and personally. Due to the course of plaintiff's employment, defendant caused Woods' NDA to be executed. So the NDA may have been initially created in a professional capacity, but may exist beyond that. So answer the earlier question of, have you heard of NDAs in a personal relationship? That may not be the purpose for which the NDA was initially created, although I think it would make logical sense there too. 6-year relationship is long? I think 6-year relationship is a fairly lengthy relationship. Sure. There are longer relationships, there are shorter ones, but sure, why not? A trust controlled by defendant has taken the position in litigation. I mean, I could understand if you took the contrary position. I'm not telling you what I necessarily think. I'm not telling you what you should think, but I think it's reasonable to view it that way. A trust controlled by defendant taking the position in litigation has taken the position in litigation the Woods NDA is enforceable against plaintiff, which makes you wonder why you're not dealing with it as part of that litigation, at least partially. It's like if there's an issue as to the enforceability of that, then one would think it could be dealt with in that litigation. Why we're doing this as a collateral is a little bit questionable. The trust has also disclosed that litigation, the defendant has asserted the Woods NDA is enforceable against plaintiff by commencing an arbitration against plaintiff based on it, which also suggests that maybe this should be held in arbitration, right? So one of the things you're thinking about as you're thinking about this in a legal sense is you're like, wait a second, is this the right court to do this? Because we already apparently have some litigation that's about this, concerning this. And we already have an arbitration that's concerning this, apparently. And now we're trying to start a third cause of action concerning the same thing. And of course, the problem is that you could potentially get inconsistent results. And that leads to its own set of problems, right? You could potentially have one court saying one thing, another court saying a different thing. And then how do you resolve that? So one of the things the court will have to resolve, and I don't know the answer to this, is going to be a function, because I don't have anything like enough information to answer the question. One of the things you have to concern about is like, wait a second, if there's other litigation concerning this thing ongoing, should I be hearing this case? So that is potentially a issue. The plaintiff believes that Wood's NDA is invalid and unenforceable. In toto? I don't know. However, these issues are not legally certain, and if the plaintiff is current doubt about her and defendant's respective obligation and rights, if any, under the Woods NDA. The uncertainty is acute and important. Because of aggressive use of Wood's NDA against her by defendant and trust, plaintiff is unsure whether she may disclose, among other things, facts giving rise to various legal claims she believes she has. She's also unsure what other information about her own life she may discuss or with whom. I mean, okay, fine. So just kind of a bare bones thing. The allegations of 1 through 9 are incorporated. A bona fide actual present and practical need for declaration exists as the right of the parties, the status of the purported contract, and parties' respective legal and equitable relationships with each other in light thereof, because defendant has asserted the Woods NDA is binding against plaintiff. Again, you wonder why, if they've truly asserted that in any sort of legal sense, why we're not just dealing with it in that context. Why are we bringing a different lawsuit? Because you don't want one court stepping on another court in the same exact issue. So this other assertion is immediately a flag that calls my attention. The plaintiff's request for declaratory relief addresses a present ascertainable controversy about the existence or non-existence of immunity, power, privilege, or right under the NDA. The requested declaration would also address at least one fact upon which the existence or non-existence of such immunity, power, privilege, or right does or doesn't may depend, whether such immunity, power, privilege, or right exists or will arise in the future, including but not circumstances of the execution of the NDA. So she's at least partially attacking the creation of the NDA in the first place. That's what that would mean. So she thinks that somehow the way the NDA was created might be a problem. So what would that be? Well, there's 3 possibilities that pop into my mind. Competency, she was drunk at the time. Fraud in the inducement, she was tricked into it. Or fraud in fact. It isn't what it purports to be. So fraud in the inducement might be possibility. She was tricked into it somehow. Or coerced into it, maybe. Okay, it's possible. The parties have actual, present, adverse, and antagonistic interests in the subject matter because plaintiff contends the Woods NDA is not enforceable, but defendant contends it is. Again, why are we not dealing with that in whatever context that's being contended? Only defendant and plaintiff are purported parties to the Woods NDA, and therefore all antagonistic or adverse interests will now be before the court following proper process. The relief sought is not merely giving legal advice by courts or the answer to questions propounded from curiosity. Hmm. The plaintiff requests the courts grant her declaration that the Woods NDA is not valid or enforceable, including but not limited to lack of consideration and unconscionability. All right. So she wants to attack lack of consideration, that she didn't give anything or, or receive something. So she gave an NDA and didn't get anything in exchange in a legal sense. Okay. I don't know. And unconscionability is hard. That's a matter of state specific law with NDAs and anything else. Unconscionability is an idea that a contract basically is so lopsided that the courts aren't going to recognize it. And unconscionability is pretty hard, but you do have state specific law. But when you see someone say unconscionability, I mean, you know, NDAs are not unheard of, and the scope of this may be very broad. But unconscionability, I don't know, man. But yeah, in the alternative, if it's valid and enforceable in any part, defining the specific scope of any obligations under the Woods NDA, including but not limited to, whether and to what extent it limits plaintiff's freedom to disclose her own experiences, the experience of her family members, photographs and recordings of herself and family members, information held, witnessed, or learned by people who are not covered by the NDA, information from sources other than the defendant, information on topics the defendant has discussed or otherwise disclosed to people who are not covered by the NDA. So maybe Tiger Woods has, by talking about certain things, given some sort of right of reply. Okay. Information required or permitted to be disclosed by law, regulation, or rules. Information responding to statements the defendant has made or published about her or others to prove falsity or misleading nature of the statements. The purported arbitration clause is unenforceable as the plaintiff in this claim, and any determination of applicability in this case must be decided by the court, not arbitrator, under the federal Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021. And the Woods NDA is not judicially enforceable in this case under the Speak Out Act of federal law. And that is the end of that complaint. So, yeah. So we don't have a lot of information to be able to adjudicate this, but she's arguing lack of consideration. She was not given anything in exchange for this, which seems implausible. Unconscionability. It is so bad that the law will fail to recognize it. I don't know about that. And then she's trying to use these federal laws that exist as a federal hook to at least nullify the thing in part, which makes you wonder the degree to which you have to at least contemplate the degree to which those things really are true, or it's just a legal hook to try to get there. And I don't know the answer to that question. I don't know what this woman has been through or what she's seen or whatever's going on. But if you're not at least asking yourself the question, and saying, there might be something here. And then again, moving past all that, you also have the issue of if I suppose it depends how the Woods Trust is going about this. If the Woods Trust is trying to enforce this against her in arbitration, and she's coming into court, if there's another court proceeding that concerns this, which I kind of read her complaint to suggest that it did, so maybe I misread it or misunderstood it. If there is a different court case in court that currently exists regarding this, then this court should be cautious. If this is already in arbitration, then the court can speak to this issue about then the issue would be then the only really issue for this court would be the would be likely to be the assault things. It would depend on the nature of the arbitration agreement and how it's written. So sometimes they're written sloppily, and I've seen ones that are written sloppily that don't cover everything. So it might be that she could get to this in court, but we're going to assume that Tiger Woods has good lawyers and didn't make those mistakes. So the only thing for this court to do would be to speak to the issue of the federal law, and everything else would be for the arbitrator to decide, because that's what the NDA applies for, and under the Federal Arbitration Act, that's how it rolls. All right. So all those good things. The press has to put out a very different reason to break the NDA. Well, they're certainly going with the more salacious allegations, you know. So yeah, she wants her family to be able to go to the press with her other claims. Maybe, maybe. I'll tell you what, though. I think that Tiger Woods is probably right to want an NDA. Given the life he lives and given the controversy that surrounds him and his problems, he's like, if I'm going to bring you inside my circle, an NDA. So yeah, I think that Tiger Woods was right, and the scope of the thing is interesting. All right, I'm going to sign off for now. If you've enjoyed this stream, please remember to give it a like and a a maybe a comment or something, and make sure that you've hit that subscribe button. I appreciate every one of you who is part of this journey as I learn how to be a good legal commentator on the YouTubes. It is fun and exciting. I've been Uncivil Law. We will be back with more coverage later. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.